By the orders of the learned single judge under challenge dated 5/5/2022, in both these appeals, the fact indicate that as far as 16/5/2022 letters patent appeal number 765 of 2022 is concerned before the learned single judge, the order that was challenged by the appellant petitioner was rejection of this objection, by which the appellant's name was deleted from the voters list, and in the letters patent appeal number 766 of 2022 his objection to get the name of certain voters from the list was also rejected. Considering Rule 28 of the rules, the learned single judge has not interfered with both these orders. Considering Rule 28 of the rules, the learned single judge has not interfered with both these orders. The position of law has been discussed by the learned single judge, which reads as under. The law as regards judicial review in the matters pertaining to election is well settled. A. The full bench of this court in the case of Dehya Group Seva Sahakari Mandali Limited versus R.D. Rohit, authorized officer and cooperative officer (marketing), reported in 2006 (1) JCD 211, held that the inclusion or exclusion of name in the voters list cannot be termed as extraordinary circumstances warranting interference by this court under Article 226 of the Constitution of India. Paragraph 31, 32, and 33 reads thus: on the question of maintainability of petition under Article 226 of the Constitution of India, in our opinion, the law is well settled. Mr. Patel invited our attention to the decision reported in 1988 GLH 430, where the principles have been clearly enumerated, and held that extraordinary jurisdiction of the High Court under Article 226 and 227 of the Constitution of India is very wide. The court should be slow in exercising the said jurisdiction where alternative efficacious remedy under the Act is available, but however, if the impugned order is an ultra vires order or is nullity as being ex facie without jurisdiction, the question of exhausting alternative remedy would hardly arise. In the case of Mehsana District Cooperative Sales and Purchase Union versus State of Gujarat (1988) (2 GLR 1606), after following the decision rendered by the apex court in the case reported in the case of Gujarat University, para. We have gone through the aforesaid decision closely. There cannot be any dispute with regard to the principles laid down therein. The sum and the substance of those decisions apply to a situation where this court would like to entertain a petition on the foundation that the order is ultra vires and or without jurisdiction or is violating principles of natural justice. Thus, in an exceptional case, this court can exercise the power of judicial review, which is a basic structure of the situation in such cases, more particularly in the election process. One thing is clear, that this court ordinarily would not like to exercise its power under Article 226 of the Constitution when the process of election has been set in motion, even though there may be some alleged illegality or breach of rules while preparing the electoral roll. Stop.